Hello everyone and welcome to this new episode of the Privacy Rules webinar series. Today we are going to discuss the first year implementation of the GDPR together with 6 of our members. We have with us Agnieszka Wiercińska-Krużewska from Wierciński-Krużewski Baehr from Poland. We have Jean-Christophe Chevallier from Ydés Avocats in France. Stefanos Tsimikalis from Tsimikalis Kalonarou in Greece. Then we have Geert from Timelex in Belgium, Péter Szaniszlai from Lakatos Köves in Hungary, and finally Kim Walker from Shakespeare Martineau in the United Kingdom. I would like to thank you all, and without further delay, I would like to start and discuss on how the first year implementation of GDPR is going together with you, Agnieszka, and then move to all the other members.
Thank you very much. It's a pleasure to present at least my part of our discussion. And I think that I'll go straight to the point, how this 1 year been with us in Poland. I think it was a very, very interesting year. At the beginning, it was all very, the media was full of information about the GDPR implementation. And I think that everyone was on one side very excited about the GDPR, on the other hand was very frightened that something extraordinary will happen. I think that the media presented GDPR as something completely new. So for most, I think for most companies in Poland, they actually realized that something like data privacy exists. Which of course for us practitioners was kind of a surprise because we've been dealing with data privacy for many, many years, and the Polish law on protection of personal data has been 10 years old. So we have implemented, we did implement many of internal regulations regarding the data protection, personal data protection. But of course, because there were no penalties and the activity of the regulator was not, the regulator was active, but without really punishing anyone for the data privacy breaches. So I think that the whole, I could even say hysteria with the GDPR in Poland was because of the amount of the penalties. So for most of the companies in Poland, the amount of the penalty that is provided for in the GDPR is just enormous. It's beyond reason to understand. So I think that was really the reason why there was so much discussion about this, and that everyone went into the business of data privacy consulting, and there were people that had never anything to do with privacy, data privacy, that started either legal services or advising services and so on. And then, it was more and more quiet. So the implementations started and finished, and the daily business came. And of course, there are a lot of questions. We waited for quite some time for the law implementing the GDPR into the specific areas of legislation, like labor law, banking law, insurance law, public procurement. So this law came into force in the spring this year, 2019. So for many companies, it was kind of a difficulty because they implemented GDPR, but they still waited for specific provisions regulating their own industry. So generally, it's quiet right now. Everyone is doing, I think, the business. So the whole hysteria is over. As I say, there are problems, there are issues. But I think that everyone understood that this is the legal regulation as any other.
Okay. And Jean-Christophe, is it the same in France? Is it still quiet there, or it's a bit different? How it's going?
Yeah, actually in France, citizens and French citizens and French companies, they are now definitely fully aware of the new regulation. if I can give you some interesting statistics and numbers, since the full implementation in France of the GDPR, the French DPA has registered more than 11,900 complaints in France, which represent an increase of 30% than before. And if you, in terms of number in Europe, we are now around 145,000 complaints at a European level. So it's quite significant. And the French, 70% of the French individuals today, they consider that they are very sensitive to data protections issues. And we have registered, especially in France, more than 2,000 notifications of data breach since the implementation of the GDPR. So again, yeah, the data protection, the new rules are now fully in mind of each French citizens and companies, but it's ongoing, and I think that there is a lot of job to do again, because this is something like very strange for many, let's say, managing director, CEO, because they always consider that data protection is not a big point. But they are trying to bear in mind that the regulation is something that they have to comply with.
Okay, and I would like to pass the word now to Stefanos Tsimikalis from Greece to see what's happening in Greece too.
Thank you, Alessandro. So the situation in Greece is a bit different. At this stage, Greece remains one of only 2 countries without national legislation to help implement the GDPR. I think, if I'm not mistaken, the other one is Slovenia. This does in fact create certain problems, since there is no certainty as to how data controllers should approach a couple of things. Where we stand with our law is rather unclear. There was a draft law that was made available back in February of 2018 in order to go through the public consultation process, where interested parties and groups can submit comments and observations. The legislator announced that they would reshape the draft. But since then, the draft law disappeared and we have not heard anything back. And there is no official timeline as to when we might expect the next draft or the law to be submitted to the Parliament for ratification. Other than that, it's pretty much as Agnieszka said. Prior to May 25th of 2018, I think organizations and businesses were more or less going about their business without paying too much attention. Suddenly they became aware of this regulation coming into force, and of course in fear of the multi-million fines, they started rushing to beat the clock in a way, in order to suddenly become compliant and avoid any consequences. And this led to a whole sort of interesting and curious approaches, and in the end we started seeing some campaigns, for instance, for the validation of consent that had no merit, and they were not warranted or justified, and organizations simply started copying one another without any proper legal background for that. Aside from that, today the Greek Data Protection Authority has become active. It has issued, to some degree, guidance on certain issues that are of interest, and they continue doing so. And they are already enforcing the regulation, but I think we'll come back to that later.
Okay. And now I would like to turn it over to Geert and Belgium. There with the European institutions, things are different, or it's quiet. The situation is pretty quiet also there.
Well, thank you, Alessandro, and thanks, Stefanos, Jean-Christophe, and Agnieszka. So indeed, now let's pass to Belgium. We're very close to where it's all happening, let's say. I'm going to make some general observations that are in line with what has been said before, and I'll make some very specific observations about the Belgium implementation and some peculiarities that are interesting to share in my view. So first of all, I agree with what Agnieszka said in the beginning. There is definitely, it's not revolutionary, but clients woke up due to the fines. It's very clear. And also what Jean-Christophe said, that there is more sensitivity now, that is clear. But within the clients, what we see, I can only speak for what we see, because maybe there is a lot of companies and organizations that are not yet aware, that aren't been doing much or anything, but our clients are. There is more awareness, and they're doing their homework in the context of accountability, which I believe is the key word of the GDPR for everyone. So that more as a general observation. What's maybe interesting to share about the Belgian Act, which was implemented last year already. Our DPA, on the contrary, also took a while to be in office. Finally, they are, and they are also getting active. But interestingly, they're focusing for the moment mainly on the public sector. What's even more interesting is that in Belgium, the public sector cannot be fined. So fines are only possible for private sector companies. But this creates, of course, some tension. And there's actually a complaint pending before the Constitutional Court for discrimination. Of course, the state says, yeah, but if we have to pay fines, then it's going to end up in the state's pocket anyway. So it's not really. But for private companies, this is a problem. It's also a problem when there is public-private partnerships or public procurement where the government is working together with private companies. Let's say there would be a joint controllership of a public and a private organization, and there would be a fine. Okay, then the private organization would be fined, but the public sector organization would not be fined. So this is a bit of a weird fact that we will see how it will be dealt with in practice. Then there is also something to say about the GDPR prohibits normally the processing of criminal data, but it leaves room for deviation in the countries. And in Belgium, such data can be processed with consent of the data subject. And this is important, for example, also in the context of background checks that have to be performed by companies, whether to know if a potential candidate has a criminal background, etc. There are many examples where this is very useful. And in countries where, there is no way around it, it becomes very difficult. And of course, we're dealing with, multinationals where we have to find solutions in the various countries. Also interesting to mention here in Belgium is that we have had always a very specific legal framework for the processing of sensitive data, and particularly, for example, health data for scientific research purposes. And it's a very elaborate framework with a scaffold approach where you should first anonymize the sensitive data where possible. If that is not possible, then you pseudonymize, etc. So this is something that we have in our law that is interesting to mention maybe. And what's also particular is the fact that when you obtain personal data from the government in Belgium, you have to have a protocol with the government. And that protocol has to be published on your website and on the government's website. And you also need a DPO when you obtain personal data from the government. So, and then last but not least, there is more, of course, but one that I would like to share is something that already existed in the past. And it's the fact that we have cease and desist order possibility explicitly written in the law for any breach on the GDPR. So in the past, it was the Belgian Data Protection Act, but now, so for any infringement, a data subject or any other stakeholder can file a petition for cease and desist against such breach. And in the past, this was actually when there were no fines yet. This was sometimes used in Belgium as a way around to, for example, go against your competitor and saying, we invested in data protection compliance measures, our competitor is not doing so. it's happened. I mean, not a lot, because when you do so, it will fire back against you. But yeah, this is a peculiarity also.
Thank you, Geert. That's extremely interesting. And then I would like also to see in Hungary. So Péter, I turn it over to you. How is going the implementation, and how is the approach of the GDPR with the related laws in Hungary?
Yeah, thank you very much. So actually the situation in Hungary can be characterized very much similar to most of your country's experiences. Especially I like the summary on Poland. The difference probably is, although it might sound quite strange, but actually the pre-GDPR Hungarian data protection rules were even stricter. For example, in terms of legal basis provided, and after the GDPR, the possibilities of data controllers actually become broader to process personal data. This goes back to probably historical and political circumstances, basically the approach of the first constitutional court of Hungary after 1990. So in many ways, now the rules in Hungary in respect of data protection are less strict than before. However, as we also heard from many of your experiences, because of the lack of effective sanctions, companies did not care too much about these rules in practice. So what really changed is certainly the awareness of companies that now they, especially right after the GDPR became applicable last May, it was really a lot of things we could see in the media, and suddenly it became a big issue. As to the actual implementation in Hungary, it happened in two steps. One part of it was already done last summer when the Hungarian Data Protection Act was amended, but most sectoral acts were only amended in the beginning of this year, which included employment, healthcare, and for example, security services like CCTV surveillance. There are still some sectors and some areas where there is no actually implementation. For example, we don't have anything particular about direct marketing. So we are still expecting some legislation. But to go back to most of your point, my impression is now that it is business as usual. Companies kind of got used to that this regulation came and it stays with us.
Okay, so perfect. Thank you very much, Péter. And then last but not least, Kim, I would like to turn it over to you and to see how is going the implementation of the GDPR in relation also to Brexit and how is UK is dealing it.
Yes, it's. Thank you, Alessandro. It's been a busy year, I think, for companies and lawyers and our regulator. And I think the view is that the implementation of the GDPR has gone relatively smoothly. The view is that generally there's a pretty good level of compliance throughout the business at a relatively basic level. So people have done what they have to do, but there's much more to be done. And the regulator, the ICO, the Information Commissioner's Office, has made it clear that in the next year, she's going to focus on making sure that the accountability principle is complied with. In other words, people really understand what their obligations are. And of course, we brought our Data Protection Act in 2018 into force in May last year, which introduced our sort of sectoral legislation, but also importantly, it effectively put GDPR into UK national law, so that if we do ever get round to Brexiting, the GDPR will essentially continue to apply in the UK, even though we won't be part of the European Union. And as I say, there's been lots of activity by the Supervisory Authority. I understand that there have been about 40,000 complaints, which is about double the previous year before GDPR. There were 14,000 data breaches reported, compared with 3,300 in the previous year. About 17% of those required further action. So all that demonstrates that there's much more awareness of data protection law and of people's data subjects' rights. And of course, recently we've now got enforcement. We've seen at the beginning of July 2 massive fines, which has the first fines issued by our ICO under the GDPR, and that has certainly made people sit upright and pay attention in boardrooms around the country. And then, of course, coming back to Brexit, we're beginning to realize that if we do Brexit, it might well be a hard Brexit. In other words, no withdrawal agreement, no transition period. So there's quite a lot of activity preparing for that, ensuring that data flows to and from the EU and between the EU and the UK can continue after Brexit.
Thank you, Kim. And yes, that's last point. It's really interesting, in particular, the relation with how the supervisory authorities are approaching the GDPR and the regime of sanctions that has been activated, and the ICO has been probably one of the scariest authorities for the moment, since we probably all know that it intends to issue a couple of very big fines. And so I would like to move to the next topic related to the GDPR, that is exactly how the supervisory authorities are approaching the use of sanctions and under the GDPR. And I would like to ask it to Agnieszka, and to start with Poland, and again see all your different point of view also under this topic.
I think that, yes, that there are again many common features of the activity of the regulators, of the ones that you've already mentioned in other jurisdictions. It also took quite some time to have the head of the Polish regulator appointed. There was a big competition between someone who was really responsible for drafting all the Polish legislation and some new people that wanted to take over this function. Finally, the head was chosen. And I guess that for the first year, the activity was mainly issuing certain guidelines and something that would tackle particular market, like, for example, schools, how the schools should implement the GDPR, and the medical sector, and some different sectors, and these guidelines were issued for these particular sectors. There were some contradictions because also some other ministries decided to issue guidelines regarding GDPR. So, for example, there are 2 or 3 guidelines issued by the Ministry of Digitalization. And funny enough, there are some contradictions between the guidelines issued by the data privacy regulator and the guidelines issued by some of the ministries. And I think, as someone already mentioned, during the first year, mainly the inspections were directed into the public sector. And it's again the same, that public sector is not really financially responsible in many cases, but the regulated wanted to make sure that the public sector really complies with the new regulations. In terms of fines, there were 2 cases. 2 cases. Of course, there were many complaints, but actually the regulator took action in 2 cases, and both these cases are very controversial. One, the fine awarded was 200,000 euro for not sending the information obligation to 6 million users of the service, which the company used the possibility to direct the information obligation on their web page. And the regulator decided that actually they were supposed to send individual letters with the information to every user, which was, tragically criticized by the data privacy practitioners, that this is exactly that it shouldn't happen. I mean, that this is not the way that the GDPR should be interpreted, to make the company, which was not the biggest company, to send individual mailing to every, to 6 million users. And the second was also quite funny. It's the fine imposed on the sport association for disclosing the names of referees, being awarded the right to be the referee in the sport association. And that fine was 13,000 euros, so not a substantial fine. But on the other side, for a sport association that is not a profit-making institution, it's a quite significant fine. I know that both cases are subject to appeal, so they are not final and binding.
So let's see how it will go.
Yes.
In our next meeting. And what about the CNIL in France, Jean-Christophe? We know that it's another pretty active authority.
Yeah, I would say that the French Data Protection Authority was waiting for the full implementation of the GDPR to take opportunities and maintain its control process and let's say and achieve some aims that was to find, especially not American company, but mostly the GAFAM, due to the fact that they consider that there was a lack of transparency, a lack of security, and not a big respect and big compliance to the data protection laws. So I would say that, yeah, the French DPA was focused on the question of the transparency, the legal basis of the data processing, and the security. Security was something like, the data security breach was the main origin of the complaint that were filed following the GDPR implementation. And in terms of example of fines, we talked about that when in Beijing, but I will start with the decision rendered on December 18th against Uber. But everybody in Europe heard about this decision because Uber was fined not only in France but also in Netherlands and in the UK. So they had to pay a fine of 400,000 euros for data security breaches that affected the data of 57 million users. So that was quite a bit.
Yeah.
Then we had the French telecommunication company Bouygues Telecom that due to an attack, and even if they reacted quickly, they considered that the data security breach was insufficiently, the security measure was insufficient. So this is the reason why the French DPA fined them for a 250,000 euros fine. And beginning of the year started with this huge, I would say the most important sanction that was rendered in Europe against Google, 50 million euro, so which was quite a bit. And the motivation from the French DPA was the lack of transparency and lack of transparency, especially to respect the right of accesses and the right of the data subjects. And recently, a decision rendered in May against a French company, a real estate development, buying and selling, renting and property management company, was fined for a 400,000 euros fine, which is very, very tough for this kind of company. because there was some lack of security, and they had no data retention period in place. So I would say that the French DPA is not only concerned by the security and by the transparency now, they are getting concerned by the documentation and the measures that has been taken, like in the back office, I mean, for the retention period, for the security measures, violation procedures, and so on. So they are going deeper into their process of control. And we are at Ydés, we are quite well concerned by that for our clients, because even if they have no control for the moment, they might have in the coming months and years, but they are quite concerned by the documentation and certification actually.
Of course, I understand. Thank you, Jean-Christophe, for your interesting points. And what about Greece, the data protection authorities in Greece?
Okay, so in Greece, in the first 12 months, there were 136 data breach notifications submitted to the Data Protection Authority, and approximately 950 complaints filed by data subjects. This is a significant increase in comparison to the years before, which is also connected to a large extent to the publicity that the entry into force of the GDPR received around May and a bit before that. But it's very interesting to see how the Data Protection Authority's approach shifted from January 1st, 2019, from being more of a passive observer and dealing mainly with breach notifications and complaints filed by data subjects, to actually initiating random inspections and audits. They had the first operation where they audited 65 businesses, mainly coming from the fields of banking and finance, insurance, e-commerce, ticketing services, and of course also the public sector, which seems to be a recurring theme. And again, similarly to what has happened in other countries, the Data Protection Authority focused on the transparency of processing and the information that is provided by data controllers to the subjects. Very importantly, they placed particular emphasis on the use of cookies on websites, and also, of course, on commercial communication and advertising. The authority has made it clear that it will continue monitoring compliance, generally on the part of controllers, and that it will continue addressing websites and cookies, especially when it comes to e-shops and networking sites like social media or platforms where users can exchange views in particular. When it comes to the enforcement on behalf of the Data Protection Authority, we are probably one of the few countries that has not seen a monetary fine imposed in the post-GDPR environment yet. The Data Protection Authority has handed, if I'm not mistaken, 10 decisions down so far by applying the GDPR. And aside from those that the authority rejected the claims, it concluded the proceedings with issuing reprimands to data controllers and warnings. So we have yet to see the first real fine being imposed here.
So I would like now to turn it over to Geert and see how the Belgian Data Protection Authority is moving, and if you also notice it is, difference in behavior between before January and after January. That was interesting.
Yeah, well, indeed. So what I find interesting, especially, is the different approaches in the various countries, not only in relation to imposing fines, but in general interpretation of the GDPR for clients. It's sometimes, well, also in the context of the one-stop shop principle, it still remains interesting to look in Europe, what countries might be more interesting, so to speak, for your business, for your organization, and try to structure your operations accordingly. It still has to match reality, but it's something that larger organizations definitely look at. With regard to the Belgian Data Protection Authority, well, as you may know, before it came into office, the old Privacy Commission had already launched important proceedings against Facebook. These proceedings are being continued for the moment, but the current president of the new DPA said that the purpose of the DPA is not to fine just for fining purposes, you know, just to show that they fine. They want to be pragmatic and, well, you know, not just have a symbolic function. Let's see, you know, where that's going to go to. In practice, we have had one fine, though, a smaller one, 2,000 euros. So it's nothing like the monster fines that we've seen in other countries. And it was actually for something that was not a big infringement. It was a mayor who had used an email address obtained in the context of a building permit for campaign purposes, you know, to send, to vote for him. And that was considered a breach. On the other hand, the, again, public sector, the Ministry of Public Health was only reprimanded last week for not having internal rules in place with relation to the GDPR. So, I mean, of course, there's always some discrepancies, but the fact that one doesn't comply of course doesn't mean that it's a justification for you not to comply. One thing that you can also say in Belgium with relation to the fines is that our DPA is not financed by the fines. And I do think that in some countries, I think Spain and maybe some others, the DPA actually has an interest also in obtaining money from the fines for its own financing. So this is something we don't have.
Okay, and Peter, what about Hungary and the data protection authorities activity?
Yes, so so far in Hungary, there have been 9 instances of imposing fines, which I believe shows that the Hungarian data protection authority is quite active. 8 of these 9 instances came from this year. So last year, the authority was busier with providing some guidelines for compliance. The interesting thing is that the amount of these fines is usually very low, like a couple of thousands euros. The largest one was the most recent, is 90,000 euros. A fine was imposed on the organizer of a music festival for unlawful processing of data and not proper legal basis retention problems. And there was a 30,000 euros fine imposed on a political party, actually, because of not reporting a data breach and not maintaining data security. But most of the other instances of imposing fines were against banks and private companies. There was only one instance when a mayor of a city was fined. So that is about the public sector in the case of Hungary. So we will see what will be coming in the future. I don't expect that we would see very significant amounts of fines in Hungary, but I would also expect that this relative activity of the Data Protection Authority will continue.
Okay, and so let's go back to the starting point, that was the ICO and the United Kingdom discussing about. Kim, was it surprising for you, the fact that the ICO took this kind of decision, or was something expected?
Well, we were expecting fines, but I really don't think anyone was expecting fines of that kind of level. 183 million pounds for British Airways and 99 million pounds for Marriott International. and throughout the year, smaller fines were announced, but they were all under our old act, where the maximum fine was £500,000. So Facebook got fined the maximum for its incompetences with Cambridge Analytica, for example. But yeah, I don't think anyone expected. It has to be emphasised that the British Airways and the Marriott International fines are announcements of an intention to fine. We haven't yet seen the imposition of a monetary penalty notice, and usually the company makes representations and tries to negotiate the fine down before the monetary penalty notice is imposed. But in this case, or in both these cases, British Airways and Marriott are stock exchange listed, so they had to make an announcement that these fines were potentially on their way. And so the view, I think, is that it's unlikely that the amount of the fines will change much between now and when the fines are actually imposed, because the ICO won't want to look as though it made a mess of its investigation if it announced 183 and ends up only fining 100 or something. And so I think that we can be pretty confident those figures will stick. And as I say, I think it's, we've been pretty surprised at the level, and it'll be very interesting when we get the full details of the reports of why the levels of fines are so high. To understand, that the British Airways fine is 1.5% of its worldwide turnover, so it could have been higher, I suppose. I mean, it was a leak of, or a diversion to a fraudulent site of about 500,000 customer records. So it was big, but it wasn't massive. And likewise, I mean, the Marriott one, which is 99 million, was a sort of malware attack of, actually, it affected 339 million customers worldwide, of which about 30 million were in the EU. So, and it was all because, ultimately, presumably, the companies didn't have appropriate technological and organizational measures in place. So we're all hoping that the reports of the fines will give us some guidance as to what that actually means. So yeah, and then of course over on the other side of the Atlantic, we find Facebook getting fined 5 billion by the FTC. So it's certainly catching people's attention.
Of course. We almost finished our time, so I would like to thank you all for joining us and giving us this roundup of overviews, different overviews that we would really like to go deeper for each country with another podcast with each one of you in the next weeks. It would be really interesting because you all raised different interesting topics that they would be really nice and interesting to discuss. So I thank you all again, and I thank all our listeners, and I invite them to follow us on our social and on our website, when they can find all our webinars and podcasts together. And I hope to see you very soon again. Bye, everyone.
Thank you.
Bye.
Thank you. Bye.
Bye-bye.